Hi, this is Curt Barone, and welcome to another edition of Fire Law Roundup.
Next case is kind of troubling, and again, it's not the first time we've seen cases like this, but out of Washington State, where we have actually an older recruit. He was 41 and was a police officer. I think he might have been a deputy sheriff. I think was his official title, but a member of law enforcement, African American, who decides to become a firefighter. Hats off to him for that. But apparently, during the academy, during rope class, during a break, one of the firefighters, tied a noose and slipped the noose over his head and then tightened it around his neck as he was on the phone with his wife. And, I mean, a noose is a fairly intricate knot. It's one that, when you're working with ropes, it's an interesting in terms of all things, but it's such a symbol today of hate, and the historical connection. And I'm not sure we do enough. I don't think we do enough to emphasize that in our academies. It just keeps coming up, and it keeps coming up, and it keeps coming up. I would say, we don't go more than a month or two without some sort of a noose related case coming up.
Which really boggles my mind. It really does. In the year 2023, this is still happening. You have to at least consider that the alleged perpetrator is somebody that put time and effort into getting where they are now. Mm-hmm. Presumably they studied for an entrance exam, etc. Why on earth would you be throwing this away? You didn't just crawl out from under a rock. You didn't just step out of a spaceship. We can't expect the departments to have to teach you every single thing.
Yeah.
You have to, at some point, you're walking in there as an adult. You're responsible for your conduct.
Yeah. Well, the allegation. I know it. And again, it's not the only one, and they just keep happening. And at any rate, the department didn't handle the investigation apparently the way that the firefighter felt the recruit felt it should have, and he ended up apparently withdrawing from the academy. I'm not sure if he went back and became a police officer, but he ended up withdrawing from the academy, and felt that the department first of all didn't properly handle it. They tried to kind of keep it out of the media, keep it off the front page. They allowed the man, they didn't say resign, but they said separate. But he was allowed to separate without any discipline. And also, apparently, there was some assurance given to the perpetrator that the department would not bring this up in a future reference situation.
Like background check from the department.
And apparently the department at the time was trying to figure out a way to get to increase the tax levy. So they were very concerned about keeping this off the front page. And they issued what the complaint characterizes as a gag order, not to discuss it, not to talk about it, which, according to the recruit, prevented him from reporting it to the police or really reporting it to anyone. And so he ended up resigning. And why that's important is his lawsuit alleges certainly race discrimination and several other constitutional issues, but a First Amendment issue that, that gag order constituted a restraint on his First Amendment right to report it. Obstruction of justice, we'd have to get into the details of whether or not obstruction of justice actually occurred. Conspiracy, certainly hate crime. I think the act of placing the noose around his neck would, I think, well, you're the expert there. What do you think about?
In New York, this doesn't rise to the level of an assault.
It doesn't?
Because to have an assault, it does not. In New York, criminally, you have to have an injury. You either have to have a physical injury or a serious physical injury. Without that, you have no assault.
Really? Wow.
So the best you've got here and I hate to say the best you've got, is aggravated harassment, which is only a misdemeanor because it's an act of harassment based upon race.
So it wouldn't be, see, in Rhode Island, an assault can be putting somebody in apprehension of a contact. So you take a swing at somebody, even if you don't make contact, that would be an assault here, and then battery would be actual contact.
I've had this argument with ADAs about charging attempted assault, and I've had people tell me, well, there's no such thing. But if I take a Louisville Slugger and I take a nice, round shot at your head, and you're an ex-boxer and you duck and weave and I miss you, well, did I not try to get you?
Yeah,
of course I did. So I've in my mind, I've got a good solid attempted assault, but I know other people that won't go for it. But you could try to charge here reckless endangerment, which is creating the risk of serious physical injury.
Well, I think we're talking civil here. The criminal side is one thing. The civil side, certainly, and I'm assuming the hate crime would be something under state law. Have to go through the complaint to take a look.
Only way under New York, I'm sorry, the only way under New York law that you'd get this to a hate crime would be charging reckless endangerment, because our hate crime statute lists what qualifies and what does not. And that aggravated harassment does not, because it's already based on race to begin with. So that just stays where it is. You may be able to charge a menacing on this, but that, again, would not be one that could be elevated to a hate crime. That leaves you with a reckless endangerment, and that leaves you with having to prove that the other firefighter created a substantial risk of serious physical injury. So there's a lot of elements in there that need to be proven.
I'm just looking at the complaint and paragraph. It's the complaint, I guess, is numbered 12, called hate crime, and it's based on a Washington statute. But the way it's pled, it sounds like they're using the language of the statute. It says that the perpetrator maliciously and intentionally caused physical injury to the plaintiff or threatened the plaintiff because of a perception of the plaintiff's race or color. So there's probably a little less burdensome than the New York standard. So
it's going to vary state to state, obviously. The sad part is when you read in the complaint the outtakes from his evaluations from the police department. From when he was in the sheriff's office. And the one that really struck me was, I would trust him with my life and the life of my family. Now, to hear that as a firefighter or a cop, to have somebody say that about you, the praise doesn't get much higher. It really doesn't. And if that's the person that you've now lost, to public service, what an incredible shame that is. And when you look at some of the other comments in there about how his dedication, his compassion, his integrity, his honesty, this is the guy you want to be working with. This is the guy you want to be, either sitting in a radio car with or crawling down that smoke-filled hallway with.
Yeah, for sure. So, well, he's got a bunch of civil claims here. There apparently, as best I could tell, there were no criminal charges brought against the perpetrator. And, he's going to try to get his day in court here. The victim is going to try to get his day in court here on the civil counts. And like you said, it's really unfortunate if he, was a terrific prospect. The department's lost him, and, hopefully he got back into his prior career. I would assume that would, once you get your certification there as a police officer, it's, you've been through the academy, he's worked as a police officer. I'm sure, hopefully he can get back there somewhere. So.